welcome once again to my channel. My name is Msiment Alex, and basically today we are going to look at the law of tort, and specifically want to appreciate the law governing assault under tort. You need to know that the assault is also a criminal issue. You can also sue under criminal, but basically today we want to appreciate it under tort. What does it entail? What do you need to prove in courts in case you're alleging the tort of assault? One, you need to know that basically assault, this is basically refers to the circumstance where the the defendant's actions uh, lead the claimant to apprehend that actually the other person or the respondent is yet to apply fear, rather yet to inflict injury on the claimant. In this case, I mean that as a result of the defendant's actions, the claimant apprehended fear. That is what I mean. The claimant apprehended fear as a result of the respondent's actions. He actually feared that the respondent is yet to apply unreasonable force against his body or his person. That is assault. What do you need to prove to court when you're alleging the tort of assault? Number one, you need to prove that actually there was an act, there was a hostile act. You must prove that there was a hostile act that made you apprehend fear. That means there was an apprehension of fear as the second ingredient. There was an act, the act which was hostile, that led to apprehension of fear, and there must be, you must have given no consent. That is being the third, lack of consent. And fourth, there should be no contact, because the moment there is body contact, then it changes from assault to battery. That is no longer assault, but now it becomes battery. But specifically here we are dealing with assault. Here we are dealing with assault. You must prove there was a hostile act. You must prove that the act that you actually apprehended fear. You must also prove that there was no consent, and you must prove that there was no body contact, making it an assault. Okay? That is very, very important. You need to know there is a very, very nice case of Stevens versus Mayers. It's Stevens versus Mayers, 172 ER at page 735. That case discusses what assault means. In this case, the defendant and the plaintiff and other people were in a parish meeting, and the meeting resolved that the defendant be chased from the meeting, just because the plaintiff, now the claimant, was chairing the meeting. Then the defendant now took it personal and moved with a clenched fist to stab the claimant. Had it not been the people who were around who stopped him, then he would have actually caused an injury. That means there was apprehension of fear, and the act was hostile. There was no body contact because he did not reach him, and also, just like I mentioned, the elements, all elements were there. Stevens versus Mayers. That case will guide you to that effect. Then there is another good case on assault, where the defendant pointed and loaded gun to the plaintiff. You point and loaded the gun to the plaintiff, and like as a normal person, we know that pointing a gun at someone, he apprehends fear because it is presumed that what if I die? What if you kill me? Then that means a you must apprehend fear. Even the act itself is hostile. Pointing a gun at someone, that is, you have to go and read, appreciate the case of Brake versus Bernard. Brake versus Bernard. That case is when a person, the defendant, pointed a gun at the claimant. You need to know that the gun was unloaded, but because as a reasonable person, you know that pointing a gun at someone will cause fear, and had indeed it cause fear. That is very, very important that you need to appreciate in that regard. But you need to know that if, let's say, the defendant knew that the gun was unloaded, then the claim would fail. That is very important that you need to appreciate. If the defendant, if the plaintiff or the claimant knew that the gun was unloaded, then the claim of assault would fail because he knew that it was unloaded. And can you fear when you know that the gun is unloaded? Therefore, it won't cause fear. It won't cause any injury. That means it was it didn't. It would not cause, of course. Yeah, it would not cause. That is very, very important. Then again, you need to know that the distance also matters. If someone is very far, that even if he shoots, the bullet won't get you, then the claim still will fail. That is very important also to appreciate. Hmm? That is very, very important that you also need to appreciate. The distance must be reasonable, that if the gun is loaded, then if he shoots, then the bullet would catch or would hit the plaintiff. But if the person, the defendant, is very far, then the claim has to fail to that effect, of course. That is very, very important that you need to appreciate. Then there is also where what we call silent phone calls. Someone calls you, doesn't talk. Someone calls you, doesn't talk. You pick but doesn't talk. You pick but doesn't talk. That one also is an element, has an element of assault, and it actually causes fear because it looks hostile. You call me and you don't talk. That is kind of hostile. That means you have to appreciate uh, the case of Ara versus Ireland. The case of Ara versus Ireland and Baston. That case, it's a case of 1998. That case is a very good case to that effect. This person would call but could not speak. Could call, could not speak. So at the end of the day, the claim arose for assault. That is very, very important. Then once again, you need to know that there are circumstances where the actions negate the element of assault. The actions negate, actually the words negate the element of assault. You do an act which is hostile, but the words that you speak thereafter negate the element of assault. For example, if I hold a knife and I be like, had it not been uh, being like during the day, I would have cut your neck. Had it not been at night, I would have shoot you. Like, your words negate the act. That is what I mean. You have to appreciate it. You have to. Let me give you a very good example right from the case. The case of Taberville versus Savage. This person had a shield, like these shields where you're guarding people. So someone was like, even he had a gun. He was like, had it not been says like during the period of like when the judge is in the community. So had it not been assessed, I would have he threatened, but later the words he spoke negated the act. That is basically what it means. Taberville versus Savage. That case will guide you the moment you take time and appreciate it. These are English cases. Take time and appreciate them. Then there is also an element of assault when the plaintiff or the claimant incurs psychiatric injuries, psychological torture of that kind, it also becomes uh, an element of assault. I would take you to the case of Wilkinson versus Downtown. It's a case of 1897, volume 2 should be, that's Queen's Bench at page 57. That case espouses so much uh, on that aspect. This person told the woman that your husband has gotten an accident and all his legs have been cut off. And because of that, now the woman started vomiting. She even suffered some psychological injuries. And later on, it was actually realized that the husband had not gotten any accident. So the woman sued to recover injuries under the tort of assault. That is very, very important. So if you appreciate that, then I once again say that we are good to go. We shall have a full video looking at the remedies under the law of tort. We shall have a video regarding the remedies awarded under the law of tort. So once again, I really appreciate. Thanks for watching. Thanks for watching. Share with friends. Let's embrace the art of learning together. Thank you so much.